Welcome. My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar series on the constitutional crisis. Our topic today is attacks on civil society, by which I mean how the Trump administration has sought to control, influence, or defund universities, law firms, and NGOs more generally, although I think our speaker will have her own definition. Our expert speaker today is Genevieve Lakier, who is a professor of law at the University of Chicago and the Herbert and Marjorie Freed Teaching Scholar. She teaches and writes about freedom of speech and American constitutional law more generally. She has an AB from Princeton, a JD from NYU, and an MA and PhD in anthropology from the University of Chicago. After law school, she clerked for Judge Leonard B of the Southern District of New York and Judge Martha Daughtrey of the Sixth Circuit Court of Appeal. Professor Lakier has published in far too many different journals, but they include the Harvard Law Review multiple times, the Yale Law Journal, the California Law Review, Columbia Law Review, and the University of Chicago Law Review, and the Supreme Court Review. Her academic accolades include 2 separate Stonecipher Awards from the Association for Education in Journalism and Mass Communications for distinguished research, which means great articles. As future lawyers, as current law students, and in my case, a law professor, we look forward to this discussion of attacks on civil society with great, and I think in our case, personal interest. Myself, I'll let you take it away. Thank you for doing this.
Oh, sure. Well, hello, everyone. Can you hear me? It's nice to be here, if only virtually, although I wouldn't mind being in Miami. It's quite chilly in Chicago. I don't even want to ask what the weather is like where you are. But we're here to discuss a difficult subject and a complicated one, which is attacks on civil society under the present administration, and to think about what that means from a legal and constitutional perspective, and also what's distinctive about what the administration is doing, because as I'm going to talk about in the next 50 minutes, it's not entirely true that the actions that the Trump administration is taking are not all entirely unprecedented or completely novel. And so there is this important and interesting question that arises, I think, whenever we're thinking about what the current administration is doing, and that is including other administrations too, theoretically, which is what's distinctive here, what's new, what's not so new, what's a transformation of degree or of kind. But I thought I would just first set out the landscape. You, I know, have done readings. You've read a variety of pieces about the current attacks, but it's just worth describing what is occurring so we have a sense of the gravity and the scope of the topic that we're talking about today. And then I'm going to talk about how I conceptualize it and what the legal constraints that I'm going to talk about are. So since coming to power for the second time, President Trump and his administration has undertaken what I think of as a pretty consistent and concerted campaign to enforce ideological conformity through not only the federal government, although there has been plenty of that, lots of firing of federal workers and transformation in how federal agencies speak, represent themselves, and how they do business. But I'm going to leave that aside because that's not civil society. But also a concerted and pretty aggressive campaign to dictate the terms on which the institutions that make up what we ordinarily think of as civil society operate in the United States. And here in civil society, it's a somewhat unclear and capacious term. It can mean a lot of different things. But I'm thinking of universities, where you are right now, major institution of civil society, private organizations, private businesses, both for-profit and non-profit. And this includes law firms. This includes box realtors like Target and Costco. This involves the sort of the vibrant business community. Non-profit organizations, the ACLU, the EFF, all of them, and more media organizations, the institutions that, I guess, is a subset of corporations, but that operate in order to produce news and information and also to disseminate news and information. So here we think of as the social media platforms. These are all the institutions that populate the world that we live in and provide important goods to members of the public and often serve as important spaces of the public, but are not themselves government or governmental, even if they are heavily funded. And it is a central presumption of our liberal legal system, I think all liberal legal systems, but our own to a particular extent, that there is a separation in ownership and control between this private realm of civil society and the realm of the government society. Now, I'll just note that it's complicated, actually, to define civil society in the United States because the government provides services that look a lot like the same services that are provided by private actors. Think about universities. Are public universities, are they members of civil society? Are they members of the government? They are government owned and controlled to some degree, but they are performing exactly the same role and function. They're often functionally indistinguishable from private universities. When you were thinking about going to university, I bet, or law school, I bet there were a range of public schools and a range of private schools, and the determining factor was not, are they public or are they private? They were essentially indistinguishable. And that's because of the extent to which the government has been used to fund public goods that are there for the public purposes. As I'm going to talk about with universities, even government-funded universities, though, are subject to different rules than those that apply to any other government sector. And so I think we put them in the bucket of civil society as well, because although they are government funded, at least to some degree, public universities are less and less government funded than they used to be. They're still not under the total control of the political branches of the government. There is a separation that is created. And so universities, businesses, nonprofits, media organizations, social media platforms, these are all part of the sphere of society that in theory is supposed to be run by, controlled by different actors and on different principles than those that govern the government. And the separation between the terrain of civil society and the terrain of the government is incredibly important. I think it goes to the core of what we think of as liberal democracy, because it means that even while governments can engage in all kinds of ideological projects on their own behalf and the people who voted them into office, and they can change their positions on a dime, right? Like think about the profound difference in the directions of the Biden administration and the Trump administration, or the Biden administration and the first Trump administration. The political branches can change their views on gender and on race and on how to spend money and on American history and on all kinds of things, depending on the will of the voters and the ideological programs that they are elected to enact. Private society, civil society, does not need to go along with them. Okay, the idea of liberal democracy is that we elect certain actors to the government to do certain things, but they do not have totalizing control over society. There is a separation between the state and us, and that separation is mediated through and helped to be shored up by all of these institutions, the institutions of civil society, that provide us alternatives to what the government dictates and has to say. So one of the reasons we have so many private universities in the United States is because of a view that students should have a lot of choices about the character and the nature of the university at which they attend. And so therefore, it is good to diversify the decisions, the policies, and the decision makers, the actors who are in control of all of these different institutions, so that you can have what in the First Amendment world, the world I'm most familiar with, is often referred to as a marketplace of ideas. A marketplace of regulators, a marketplace of ideas, lots and lots of different choices. Okay, so this fundamental separation between the world of civil society and the world of the government is understood to be really crucial to guaranteeing freedom, because it means that if we like what the government's doing, that's great. But if we don't like what the government's doing, we have all kinds of choices. We have different kinds of environments that can create different kinds of points of view, can bring people together collectively to argue for different ways of doing things. And there can just be a sort of pluralism in the social order. The problem, however, with this lovely formal separation between the realm of civil society and the realm of the government is twofold. And these are deep problems in liberalism theory and practice, both in the United States and elsewhere. But I'm just going to focus on the United States. The one is that the government regulates all of these entities. And this is necessary because, of course, the government is also the last guarantor of our safety and welfare and privacy. And precisely because these civil society organizations are really powerful actors in their own right and can exert all kinds of power over their members and their constituents and their consumers, it is important that they are subject to regulation by an outsider. And the typical outside regulator is the government. So one, the government can regulate civil society. So this undermines the separation between the public and the private realms. And this is one reason why the legal realists in the early part of the 20th century called into question the idea that there is any kind of simple distinction between the public and the private, the kind of distinction that liberal theory depends upon. They question whether that really made sense and how to think about it, given the omnipresent role that the government played in structuring not just the economic market, but all aspects of civil society operation, including the areas where the government doesn't regulate. Often those are by choice rather than by compulsion. So that's one problem. And then the second problem is one that I just alluded to and has emerged as an increasingly significant problem right now, which is that the government funds a lot of civil society organizations. And this is because some portions of civil society, and this is at least if we're taking my expansive view, which includes for-profit corporations within civil society, as I think you should, but some parts of civil society can operate according to a largely market logic where the institution flourishes or doesn't flourish depending upon whether consumers are willing to pay for its services. But there are many parts of civil society that are intended to not operate according to a purely market logic. They are providing goods the market cannot, or at least the fear is, may not sustain, like the good of education, like the good of information, like the good of charity or public health work. So many of these goods are hard to sustain on a purely capitalist justification. And so there, the government will often step in, and here I'm speaking of the state and federal governments too. I'm just talking about government in the aggregate, government will often step in to provide public goods or to give to these private institutions or these public institutions that are part of civil society, like public universities, these quasi-private institutions, funding so that they can provide a public good that the government doesn't provide itself. But that also gives the government a tremendous amount of leverage over these institutions that are part of civil society that are supposed to be formally separate. So both through coercive mechanisms, through direct regulation of civil society, and through these kinds of more positive funding mechanisms, it turns out that governments have a great deal of, that the separation between the public and the private is a really messy one. And in principle, the government actors have potentially a great deal of leverage to push and pull what are supposed to be independent actors in their preferred direction. And I think I'll just note, by the way, on my view, like that is not an argument for rejecting the importance of the distinction between civil society and the government, or the public and the private realms, or a reason to reject the idea that these really powerful institutions are playing an important role that is fundamentally different than the role that government plays. But it is to recognize that maintaining the separation, maintaining the limited nature of government that is sort of built into the DNA of liberalism is a tricky thing, because it is important for government to regulate. And I think, there are people who take a kind of libertarian view, which, faced with the messiness of all this, just say, well, the government shouldn't interfere at all. We should have a much simpler line between the public and the private realms, which is that, and I actually think, I think this argument is coming back with a bang right now, faced with evidence of the dangers of allowing there to be powerful government action. And I really want to resist it. It's just much too simple. But there is an alternative approach, which is to say, well, look, if you allow the government to regulate civil society and you allow the government to fund civil society, then it gives the government too much power over civil society, such that the public and the private distinction is ultimately eroded or made meaningless. And so we should just have a small government. What did Margaret Thatcher say? So small we can drown it in the bathtub, that doesn't regulate and doesn't fund and doesn't provide public goods that the market cannot sustain, cannot provide itself. And that's the best way to protect liberty. I think that is a terrible way to protect liberty, because it turns out that it is really important to regulate these powerful institutions for all kinds of good reasons. And it is really important to provide public goods even when the market won't sustain them. But it means that, and certainly this is the view that has been taken in the US case, and I think the US case is one of the best test cases for libertarianism. There have been strong libertarian strains in the United States for a long time. But libertarianism has never won out because of the important public needs that government action provides. And so as a result, there's been an effort to allow there to be this kind of messy line between the government and the private, this is sphere of civil society, but patrol that line. And one of the major mechanisms by which American law, including American constitutional law, has patrolled the boundary between the government and the civil society, the sector of the private realm, the civil society, has been through the First Amendment. So the First Amendment, as it has been understood in the 20th and 21st centuries, essentially says that the government can speak and associate and pursue ideological ends in its own sphere. Government actors can articulate government points of view. Government actors can dictate the expressive choices of their employees, their hierarchical subordinates within the government. This is a realm where the government gets a lot of power. But what the First Amendment says is that the government actors may not dictate to private persons, private institutions, or private corporations, okay, everyone who makes up civil society, what they may think or say on contested matters of opinion or contested matters of fact, or how they may associate together. And so one way I think of understanding the First Amendment, I think a very appealing way, and the way that the court has emphasized in recent decades, is that it is one of the primary constitutional mechanisms for protecting and defending the separation between the public and the private spheres, while still allowing there to be regulation and funding of the civil society sphere, by saying the government can fund and the government can regulate, but it cannot do so in a way that is intended to or has too much of an effect of making it impossible for the recipients of the funding or the recipients of the regulation to have their own opinions on contested political or social or cultural matters, or associating together to foster particular points of view or political projects or ideological campaigns. And so that's how we think of the First Amendment today, and that's sort of generally what the court, I think, means when it says the First Amendment is supposed to create a unimpeded marketplace of ideas that allows the government to act in its own sphere, but it's supposed to stay out of at least the idea generation capacity of civil society. But it's always been very messy. What is breathtaking, I guess, incredible, dramatic about the last, by now it's been like 7 or 8 months, is the extent to which the Trump administration seems to be aggressively attacking this fundamental presupposition of the modern First Amendment and the separation between the realm of civil society and the realm of the government that it is supposed to defend. So from day one, essentially, of the Trump administration, the president and the members of the administration have been attempting to insist that the administration's view of truth and merit and virtue, all of which the administration articulates quite plainly and quite aggressively, are also the views adopted by institutions within civil society. And this ranges the gamut when we're talking about the kinds of things that are on the table here, from the administration's view of the truth of gender. Who is a man? Who is a woman? What does it mean to have a particular kind of gender identity? The Trump administration has taken a very strong view on that position. There's only biological gender. There is no such thing as transgenderism other than as a mental disorder that reveals a kind of character flaw. This is the view adopted by the administration. And I'll just note, just as an aside, that under the First Amendment, this is the view that the administration can take as an ideological point of view that it is trying to promote in the public realm. The First Amendment doctrine of government speech gives the administration the freedom to do that. But at the same time, it is not a view that the administration has just felt content to hold itself. It is also a view that it has insisted that any recipients of government funding also hold in order to continue to receive that government funding. And so here is just one example of how I think this was the day one executive order, that the Trump administration was insisting that its view of truth, and it used the language of truth quite unapologetically, its view of what is the truth of what is in fact a contested matter, must be also the view of everyone who receives government funding. And in the case of universities and certain kinds of civil society organizations, that's going to be a vast majority of the organizations that make up the civil society landscape. The government, the administration also says similar things about the embrace of diversity, equity, and inclusion perspectives and speech, although here it danced around the matter a little bit because in some of its anti-DEI executive orders, the administration sometimes referred to unlawful DEI as if it was working within an existing framework of law. But in its practice, it has interpreted DEI much more expansively than any anti-discrimination laws or any administration had previously understood it to be. And then just more broadly, the government the administration has insisted on dictating the terms and conditions under which institutions in civil society operate to an extraordinary degree, despite the fact that many of these institutions are private and all of these institutions exist within civil society and are not supposed to be subject to the control and the dictates of the central government authorities. And so I think the university case is the clearest case. It is the area where the sort of instructions have been most detailed and ambitious. But I think it is representative of a larger set of actions undertaken by the Trump administration to do the same thing. Okay, so what has the administration done with respect to universities? I bet a lot of you are familiar with a lot of this already. It's been in the news a lot. But just to go through some of the moves that the administration has made when it comes to universities. So first, the administration, right from the get-go, and this is building off the, I think, largely, well, I don't know, bipartisan, but Republican-led anger at what was perceived to be the failure of university administrators to take sufficient action to repress the pro-Gaza student protests that broke out on campuses around the country a couple of years ago in the wake of October 7th. In response to and building on the unhappiness with that decision, the administration, when it came into office, from the beginning, began to take an aggressive stance at changing, I guess we could think of it as regime change on university campuses, demanding that administrators make different decisions when it comes to, and I'm just going to, the range of things that administrators had to change. Well, they had to change how they regulated student protest. Okay. The administration both through the vehicle of the Department of Education, and through the vehicle of the Department of Justice, and then through a series of executive orders, articulated very clearly that it was unhappy with the leniency that university administrators had greeted student protests, and insisted that universities impose very clear and harsh discipline on students who broke their protest rules, their time, place, and manner rules, hosted encampments, engaged in sit-ins in libraries, and did things of that manner. From a First Amendment perspective, this is not up to the central government to decide how universities handle student protest. The general rule from the First Amendment perspective, in line with what I've said to you so far, is that when it comes to speech on private property, it is the decision of the private property owner about what speech to host and how to regulate that speech. So certainly for private universities, the private university has full scope of authority to decide how it wants to regulate speech on its campus, whether it wants to allow students to have encampments or not, and how it enforces its rules. And this is because of the separation between the public and the private realms. Again, it's complicated because many private universities have decided to adopt quasi-First Amendment rules. So again, the separation between the public and the private realms is the messy and complicated one, because functionally there often is not a difference between publicly funded entities and privately funded entities. But in general, universities, both private and public, the decision about how to deal with students who violate the rules or how to deal with protests on campus is typically made by university administrators and is not subject to central control. But the Trump administration said universities that do not enforce swift and severe discipline against students who engage in protests could be subject to Title VI and sometimes Title IX investigations. This is the federal anti-discrimination laws that prohibit race and national origin discrimination or sex discrimination. And upon a finding of noncompliance, or even before that, you could lose your federal funding. And none of this is being rooted through courts who have power to decide what counts as discrimination or not discrimination. It is an effort to, by using the language of discrimination or anti-discrimination, to control how universities regulate speech on campus. Similarly, the administration has said in order to continue to receive federal funding, universities have to shut down all DEI projects, institutes, and speech, including in a kind of infamous letter written in February of this year. The Department of Education suggested that this included things like trainings about implicit bias or white privilege. That was considered also to be the kind of DEI speech that violated the federal anti-discrimination law and that could lead to a university losing its federal funding. Also has required universities to change how they govern their departments. So in the infamous or famous deal that the university struck with Columbia, that the administration struck with Columbia University, the administration demanded that Columbia put its Middle Eastern Studies Department, African Studies Department, into receivership. That is to say, under the control of the central administration, who would then be subject to the implicit control of the federal government, to change how they taught about the Middle East and about Israel and Palestine. And Columbia didn't in the agreement that Columbia ultimately reached, it didn't use the language of receivership, but it did appoint a new provost who would oversee hiring and curricular decisions in that area. So we see how the administration intruding very far into the everyday business of universities. And I'm sure all of you have heard, or many of you have heard, about the Compact for Excellence in Education that the administration unveiled a few weeks ago, which it offered to a select 9 universities and then opened up to everyone, in which it promised that the universities would receive priority funding if they made an enormous number of changes to their operating procedures, including changes to how they admit students, how they give financial aid, how they hire, how they run their departments, and how they grade. I don't know about you, but I was really particularly struck by like the desire of federal bureaucrats in Washington to tell me how I should grade my classes. It is an incredible, and then also a requirement that universities provide on an annual basis extensive data about their grading policies and practices, their hiring demographics. They would poll everyone on campus, how are they feeling about the sort of new changes, and all of this would be disclosed on an annual basis to the federal government so that there could be ongoing surveillance and control. It is an extraordinarily ambitious attempt to both surveil and thereby control universities that are members of civil society, and among the most, at least in the First Amendment world, understood to be the most insulated from government pressure because they're performing this really important role, which is, I'm sure you all know, right? Knowledge production. That's what you're learning. You're learning about truth and knowledge, not just opinion. In the class, you're getting actual facts, not just everyone's just not free to spout off what they think. You're supposed to engage and critically analyze the world as we know it. And that is a project that the cases have recognized for decades now is not well served by being subject to the control of political actors who are themselves subservient to electoral pressures. And so there's always been sort of maximal separation, or this, in theory, supposed to be maximal separation between this realm of civil society. This is like the beating heart of civil society, the most protected area of civil society, and the government. And here we have the Trump administration aggressively attempting to control what universities, both public, but in particular private, do on campus and how they regulate students. We've seen, and faculty, we've seen similar kinds of efforts when it comes to law firms, another area I'm sure close to your heart. But the administration has, through a series of executive orders, threatened to deprive law firms, in this case, not of federal dollars mostly, but of access to government property, government personnel, and security clearances. And also, I think implicitly by threatening clients of the firm to also lose their ability to access government contracts and government personnel in an effort to dictate to those law firms what clients they can take, what clients they may not take. You don't get to take clients that are opposed to the administration. You may not institute lawsuits that we don't like. And also as an effort to pressure them to fire attorneys that the administration thinks of as its ideological or political enemies. This is among the core examples of why it is important to have separation between civil society and the state. If you want to have a society in which there is capacity to criticize and to hold accountable the politically powerful leaders of society, you need to have a set of institutions, let's call them law firms, that have the expertise and the knowledge and the capital to be able to actually use the laws that exist that impose, in theory, a sort of a rule of law values, equality, and accountability against the politically powerful. And yet the Trump administration has been attacking sort of this core precept of rule of law in a liberal democracy, which is that law firms get to criticize and challenge the legality of the administration's decision-making. And in some cases, quite successfully. There was a newspaper article, I think just yesterday in the New York Times about how, and I've experienced this in the First Amendment world, how large law firms that have the most at stake right now, depend the most on access to government personnel and have the sort of a wide range of clients who are worried about being associated with a firm that has attracted the ire of the administration. These law firms are refusing to engage in litigation when it's seen as politically perilous. In the First Amendment realm, I'll just say that for decades now, many very important First Amendment cases have been litigated by or supported by the pro bono practices of the large law firms. And this is very much dried up because, as you can imagine, a huge amount of the First Amendment, the free speech work that is occurring right now is against the government, is against the federal government. So it's very hard. Most of the really important free speech cases are going to be politically perilous. And the large law firms are really just not providing support for those cases anymore. So there's been a bottoming out of the market in legal services when it comes to these important constitutional cases. Lawyers are working overtime, scrambling to find people. I get emails all the time. Do you know of anyone who can provide support for this case? Because of the success of the attack on the independence of the law firms. Media organizations have also been subject to attack from the FCC and the threat that they will get merger approval by the Federal Trade Commission. And then there's been an effort a more recent effort, and I think more diffuse, we're going to see what happens to it, about to attack the independence of nonprofits by threatening their ability to raise funds and to organize. So pretty much anywhere you look in the landscape of civil society, what you see is the Trump administration rather aggressively attempting to undermine the independence of these institutions by using the two forms of leverage that it has at its disposal and that the governments have always had, but that have not in the past been used so aggressively. And the first is regulation. But here, I think it's actually what's so revealing about the efforts, the actions that the administration has taken, is that primarily the leverage has not been sort of neutrally applied laws that Congress has enacted or that the state governments have enacted that regulate these institutions to some degree, a little bit, and I'm happy to talk more about that. But for the most part, it has been the power to approve or to give licenses. These kinds of highly discretionary decisions to grant a private actor access to some kind of important privilege or benefit. Think about with the universities, the ability to receive foreign students, to be part of the overarching federal system that permits universities to often, in a very important way, make money by admitting foreign students to work at them, to study at them. The administration has threatened the ability of institutions like Harvard to receive foreign students, or in the case of the media organizations, their approval for mergers and for federal broadcast licenses. When it was the sort of infamous case of Jimmy Kimmel and Brendan Carr, the FCC commissioner, threatening ABC if they didn't do something about Jimmy Kimmel's show after he engaged in what was understood to be sort of really objectionable commentary about the murder of Charlie Kirk. There it was by invoking the threat that the FCC would revoke the broadcast licenses of the broadcast stations that were affiliated with ABC. So on the one hand, this licensing power turns out to be incredibly useful leverage when it comes to civil society organizations. And then on the other hand, the spending power. The primary technique that the administration has used to bring universities to heel, and I think it has been incredibly successful, if not without limit, is by threatening their federal funding. And this is partly a consequence of the fact that over the past 6 decades, state funding for universities has dried up to some degree or has decreased, and federal funding has become an incredibly important source of funding, certainly for all of the major research universities in the United States, but in the form of federal tuition grants, like Pell Grants, for all universities in the United States. It's really important, the federal funding for students and for faculty, and not just for research. And so by threatening this, the administration has been able to use an enormously powerful stick to coerce private institutions into compliance. And I'll just say, even for universities that in theory are resisting this pressure, like Harvard University, which after not being sure which path to take, was presented with a letter of demands, a list of demands that was just went too far in undermining its independence for even the administrators to agree to. Even Harvard, I think, has been looking as hard as it can for an exit, for a backdoor, for a way to reach an agreement with the administration, because the enormity of its dependence on the federal government is such that even if it wins, say, a First Amendment lawsuit against one or two of the actions that the administration has taken against it, it worries that in the end it will be the loser. And so just today, I guess just to sum up the descriptive part of my spiel, today we're in a period where, to a degree, I think that is unprecedented, the failure of our existing political, economic, and legal framework to successfully protect the independence of civil society from government pressure and threats is really apparent and poses you're the next generation of lawyers, I think poses a profound challenge, a design challenge for those of us, and I hope that's most of us, if not all of us, who are committed to the principles of liberal democracy and pluralism, which underpin it. This idea that in order to have a society in which there are lots of different people who think lots of different things, you just have to have a society in which there are spaces for different people to come together and agree on things that others don't agree with. That's sort of a fundamental presupposition of liberal society, that rather than using violence to enforce uniformity of opinion, we're just going to allow there to be lots of different spaces for lots of different people and lots of different views. This is, I think, centrally under attack right now. And it's not true with respect to everything, right? The Trump administration, although actually, I was going to give a lighthearted example of when it comes to TV shows, people are still allowed to have differences of opinion. But even when it comes to the realm of culture, the administration has been very aggressive in its attack on what it understands to be sort of threatening and undermining public culture, which is part of its attack on ABC. Thinks ABC is a source of great evil when it comes to the transformation of making culture too woke. And so in pretty much every aspect of civil society or private life, the administration has been trying to undermine or co-opt and control what are supposed to be pluralist, diverse spaces in which there's lots of different points of view and impose its own point of view. Now, I think the argument that the backers of the administration would make is that it's not the first to do so, that what it is responding to is what the administration describes as the tyranny of wokeness. In fact, what it is responding to is the failure of pluralist democracy under the Biden administration to survive because of the imposition of a uniform set of beliefs or cultural attitudes that everyone had to ascribe to. I'll just note two things about that. So one is some of the things that the administration is doing are in fact building on practices and tendencies that were apparent under the Biden administration. I think it's unprecedented in its scale and aggressiveness. But the problem of a federal government that has so much power in so many ways that it is undermining the independence of civil society is not a new problem. And so, for example, if we think about federal anti-discrimination law, so I talked about Title VI and Title IX before. Those are the laws that guarantee or prohibit universities, all universities that receive federal funds, which is the vast majority of both public and private universities in the United States, prohibit them from engaging in racial discrimination or discrimination on the basis of national origin or color, and then Title IX prohibits against sex discrimination. These are really powerful and important laws. Title VI comes out of the civil rights movement. I think I would imagine that we all agree that it is important that universities do not racially discriminate. They're serving an important function. But there's always been this question, like what counts as racial discrimination or sex discrimination, and when does sex discrimination or racial discrimination shade into political opinion? And up until, I would say, the Obama administration, the response to these questions, it was sort of very unclear in the First Amendment cases what counts as race discrimination if you use a slur word, or if you argue for a white supremacist point of view, or let's say a black separatist point of view. Is that race and the university allows it? Is that aiding and abetting race discrimination, or is that aiding and abetting students' valuable political opinion? Okay, sort of a certain amount of ambiguity about where the line between these two things are. But up until the Obama administration, the attitude taken by the federal government when it came to enforcing these statutes was relatively minimalist. We do not want to intrude on the sphere of protected advocacy and association, so we're going to interpret these statutes quite narrowly and enforce them quite sparingly. There was lots of criticism of this from civil rights advocates who thought that actually the enforcement of Title VI and Title IX was way too dialed back. But at least partly this can be understood as a response to this desire to preserve this important separation between the government and the civil society realms. Under Obama, the administration, I think in response to growing polarization in Congress and a failure to be able to enact sweeping new laws, the Obama administration uses Title IX, reinterprets Title IX aggressively to require a whole new slate of protections and procedures in cases of sexual assault or reported sexual assault. In response, I think very understandably, in response to what was only then being revealed as a crisis of sexual assault and sexual violence on the nation's campuses. But rather than going to Congress and enacting a new law, the administration just uses its spending power and the threat that if you violate Title IX, you're going to lose all your federal spending dollars to require colleges and universities to adopt what many thought were, really problematic processes and procedures that didn't give accused defendants sufficient due process rights without any public commentary or transparency or recourse because of the threat of taking away the dollars. And so I think that was the beginning of what we are seeing today, which is the use of the spending power as a means of leveraging, of enacting political and ideological projects that it is, for whatever reason, too hard to use the ordinary democratic political process to achieve, and thereby evading the constraints that the First Amendment ordinarily imposes on this kind of dramatic and aggressive action. If they had gone to Congress to enact this, there would have been political debate and disagreement and potentially First Amendment challenges, but they try and use the soft power that is the spending power. And so what the Trump administration is doing is not entirely new here. There have been these problems with the separation between the public and the private spheres for, I think, a long time that have been worsened by growing political polarization and the dysfunction of our political process that has encouraged federal actors to use whatever forms of leverage they have to impose through something like fiat rather than through political process or through persuasion a particular view of society on everyone. And so I think there's some merit to the arguments that, well, the Biden administration did it anyway. The Biden administration, the Obama administration, they're responsible for similar kinds of actions, but nothing of the same scale or severity or aggressiveness. And in fact, I think what we're seeing right now is, and this is why it's kind of a crazy time to be a First Amendment scholar, is first, the laying bare these deep structural problems in the way our system is set up. If the fundamental purpose of the First Amendment is to protect the separation between the public and the private realms, and the Trump administration is, as I've discussed, in all of these different realms, running roughshod over that fundamental separation, what is the First Amendment doing? For First Amendment scholars who have often believed we have the strongest free speech protections of any country in the world and are very proud of our First Amendment tradition, the current moment is a shocking moment because it really raises the question, what is this legal doctrine doing? Now, I should note that there are lots of good cases in the lower courts that are preventing or limiting what the administration is doing. But the scale of dollars on the line, both when it comes to permits and merger approvals and when it comes to direct federal spending, is so great that what is occurring in many cases, institutions are not standing on their First Amendment rights. They're not going to court to say, you may not do that, which means that even if they do have a formal First Amendment right against this kind of government intrusion on their autonomy, they're not exercising it. And in the absence of exercise in a judicially based adversarial system of law like our own, if you don't stand on your rights, you lose them. And so what we're seeing is that although there's, in some respects, really good doctrine protecting against many of the things that the administration is doing, I mean, another reason it's a kind of amazing time to be a First Amendment lawyer is because the administration is so aggressively flouting so many of the basic rules of the modern First Amendment. It is quite extraordinary to see. But it's often doing so successfully because universities or law firms or media organizations or other civil society actors are afraid that even if they win the battle, they will lose the war. Because ultimately, the federal government is in control of federal dollars, and it is hard to get a court to order the federal government to provide funding when it doesn't want to, or to provide regulatory approval, given how discretionary this often is, if it doesn't want to. And so it is hard to guarantee that you will be okay, you will survive if you challenge what the administration is doing. I think one way to understand what the administrators at Columbia University were doing when they agreed to a deal with the administration that I think violated many of their First Amendment rights and the First Amendment rights of their faculty and students was that they were afraid that they would cease to exist as a university if they kept fighting, or something close to it, that the struggle here was existential. And that fact alone, I think, raises really profound and deep questions about, well, do we live in the kind of society that we thought we lived in? Is there, in fact, a fundamental separation between the public and the private realms that liberal democracy is supposed to depend upon? Do the doctrines that in theory are there to protect this fundamental divide? And I think the primary doctrine is the First Amendment and the First Amendment free speech clause rules. But not only that, if they're not working now, what does that mean? Are courts not sufficient? Do we have to find another mechanism? Do we have to, I ask my students this all the time, do we have to reimagine the centrality of the federal government as a provider of public goods? Would it be better if instead of universities receiving dollars from Washington, they receive dollars from Springfield or whatever their state capitals, their state governments? Would that be better? But what about the inequality that would produce? Like, what do we do about a system in which the way the system is supposed to work is revealed to be not at all how the system works, particularly in moments of crisis? And so it's kind of it's kind of a terrible time to be thinking as a lawyer right now, but in particular to be thinking about freedom of speech as one of the primary guarantors of the independence of the civil society. But I think there can be no avoiding the fact that although this has been building for a long time, for decades now, I think the line between the public and the private realms has been undermined by the sheer power and weight of the federal government. As the federal government gets richer, as it gets more important as a center of regulation and permission, the threat of this kind of thing occurring gets greater and greater, even while correspondingly the ability of the political system, because of polarization and the rise of the presidential power has been weakened, has been coming for a long time. I think there's no doubt that what we've seen over the last 9 months outstrips any of the undermining of the public-private distinction that we have seen before. It's like it takes what occurred before and puts it on steroids, and then does it really fast while rollerblading something. Like that's how it feels. Everything is just speeding up, and it's all occurring so quickly and continues to occur. And so it's just a sort of profoundly existential moment, I think, for liberal democracy in the United States, but also for the legal doctrines that are supposed to guarantee that. And then the question is how to think about it. As I suggested right at the beginning of my talk, I don't think the response is to embrace libertarianism, because there's all kinds of problems that we do want the state to solve. But how do we guard against this in the future? How do we design a federal government that is not so easily capable of being used to repress dissent, chill speech, and create a kind of ideological conformity, or attempt to create ideological conformity in all sectors of the public and private realms? I think that's the question that my generation, but also your generation, is going to have to answer over the next years and decades. So I think I'll stop there. I've been talking for 50 minutes.
That was terrific. And I'm so delighted to meet somebody who talks faster than I do.
Sorry, everyone, that I spoke so quickly. My students
wonderful.
know in my class.
I have to ask, before you go, I have one question I've asked all of our speakers.
Yeah.
Which is it fair to call this a constitutional crisis?
I don't know what else you would call it. The basic framework of the Constitution is being violated. We have no functioning Congress. And we also have we have a profound threat to the separation between the public and the private realms, which is also, I think, a fundamental precept of the Constitution. So I think in at least two realms, besides all the murdering people on boats in the ocean, besides from that, in the sort of breakdown of the rule of law, there's just sort of a profound threat to what the very basic values that we think our Constitution stands for occurring, a profound attack on it without any obvious recourse. And so I don't know what else you call this if not a constitutional crisis. What do you think? Do you think we're in a constitutional crisis?
I should ask the students. I mean, I will tell you that all our speakers, just about 1 out of 3 have said not yet. Wait until they disobey a Supreme Court decision.
I just think that's way too thin a view of what the Constitution means and requires.
I don't disagree, but I've been fortunate and able to bring our class a diversity of views.
Mm-hmm.
Well, again, thank you so much for doing this. I know you have another meeting you have to go to.
Yes, unfortunately.
So,
it's been a pleasure, and I'm curious to hear how discussion goes. Bye, everyone.
Thank you so very, very much.
Bye.
We'll take our usual 10-second break and reconvene.